Welcome, everyone, to this episode of Build America, the national podcast that's capturing and sharing the very heartbeat of construction and development. And I'm your host, Kerry Smith, owner of Construction News and Review, or CNR Magazine. And in this episode, we are delighted to welcome back attorney Quinn Murphy, shareholder at Sandberg Phoenix, and he heads the construction and receivable recovery industry teams there. Quinn represents contractors in non-payment claims in all 50 states, and he also helps contractors create their own internal collections policies to help them maximize recovery. Quinn, it's such a pleasure to welcome you to this episode of Build America. Thanks for actually coming back on and joining us again.
Great to be here, Kerry. Thanks for having me on.
You got it. Let's dive right into today's topic because I know it's meaty and you've got a lot of good stuff to share with our viewers and listeners. And we've titled this The Do's and Don'ts of Construction Collection. And I know, Quinn, before we started rolling the tape, you were mentioning how ubiquitous collections issues are among construction industry firms and that you're seeing them in nearly, if not all, 50 states that contractors and others are struggling with just collecting for the work they've done. Tell us a little bit about how widespread these challenges are.
Sure, absolutely. So it's unfortunate within the industry, but I always tell clients that for the first probably 10, 15 years of my career, cases and non-payment disputes got settled based on goodwill. And a contractor would want to do future work with whoever he had a minor or even major dispute with, and that provided an incentive to work something out. In the last 5 or 10 years, it's really become more on leverage. And people are not doing as many jobs with each other, and the goodwill component, unfortunately, doesn't just seem to be as important. And so maintaining your security has become the way of obtaining leverage that drives settlement and resolution of some of these disputes. All of my contractor clients don't like this, understandably. They'd rather go back to the old system, but at the end of the day, that's where we're at right now. And so this is a key component to maintaining that leverage.
With all the challenges that, as you're speaking, I was thinking since the pandemic and the supply chain issues and inflation, and you name it, a lean, too lean workforce, this has to just be the kind of the barnacle for construction firms that are just trying to get the job delivered. I can't imagine how time consuming it is if people aren't able to stay on top of this.
Yeah, it's time consuming. And the bigger problem is just the cash flow problem because contractors, particularly folks who do projects in multi-state, some public projects, some private projects, they have multiple jobs going on at once and they're dependent upon cash flow to make those work. And when one job gets behind in terms of payment and a dispute arises, it impacts multiple projects. And then for the contractor, that can jeopardize the longevity of their actual company. It's really important. The cash flow component of construction, like I said, has become really important. Of the 38 or 40 states I'm currently litigating in, a non-payment aspect is at issue in all of them. Even if it's a more complex delay or construction defect type of litigation, there are underlying payment issues that bring this to the forefront. So understanding kind of the do's and don'ts and just some basic tips to help make that more efficient and effective, I think is key in today's industry.
Awesome. Quinn, let's jump into the do's first. And I wonder if people are listening, even if they're not directly a commercial contractor, they're going to learn from these do's and don'ts and extract information that they can use as well. But go ahead and jump into what should construction companies be doing?
On the dues side, these are suggestions help at making your collections process more effective, more efficient, and more productive at the end of the day. And the first suggestion is self-explanatory, but it actually is the most important suggestion. And that is when you're considering a system, suggestion one, have a system. This is not a contractor's favorite aspect of their job. Frankly, it's probably their least favorite. And a lot of folks put it at the bottom of the list in terms of creating a system that helps them intentionally and efficiently pursue payment that they're entitled to. But I think that's just the opposite. I think the key to the whole thing is having a system. And once you have a system that's intentional and has well-defined parameters, then you can better understand what you need to do to get paid on your work. So sitting down and taking the time to design a system is my first do. As part of that, I would also say two things: set parameters. In other words, what I mean by that is how big of a receivable are you going to pursue, and how big of or small of a receivable are you not going to pursue, and how are you going to pursue it, whether that be through a collections agency or an attorney who bills hourly or a contingency fee attorney. Understanding the role that those service providers play in any comprehensive receivable recovery or collections program is key. So that is really the biggest step: have a system and make it intentional. The second step that I would say or do is always serve a notice of intent, or some states call it a notice of furnishing, on all projects. A form notice that some states require for projects and some don't, to preserve your mechanics lien rights. The key that's important is that almost every single state's mechanics lien laws are completely different, and it's impossible to get a hold of every one of them. But there's no harm in serving a notice of intent or a notice of furnishing in a state that doesn't require it. But there's a big benefit to serving it in states that do, because it preserves your mechanics lien rights. So as just a blanket, if you serve a notice of intent to lien or a notice of furnishing, which basically tells the owner, hey, I'm a subcontractor or a supplier or whatever you may be, and if I don't get paid on this project, I'm going to enforce a mechanics lien. If you just do it on all your projects, you've got the bases covered, and it's a good way to just blanket comply with that first statutory requirement.
Let me ask about that, for those of us that are more tangential to the industry. At what point does that get served? Is this after there have been unpaid invoices, or what is 30, 90-day kind of thing?
Yes, that's the key. Actually, these notices are preliminary notices, and they
Oh,
actually are triggered by the first date that you start providing labor or material to a project in states. So
okay.
they're all different deadlines, but if the first time you provide labor or material or mobilize on a project, you serve this notice, you will have pretty much complied with all of them. And again, if states require it, you've checked that box. If states don't require it, you've done no harm. That's why I think it's a general project regardless of state, and easy to track and maintain as an internal policy. Number three is know that you have, everybody know, number three is know your contractual and legal rights beyond your lien rights. Okay, everybody knows and wants to talk about mechanics liens as the most effective tool to get paid on projects, and they are. They effectively threaten the owner's interest on the project, and it gets his attention, and it forces him to get you paid either directly or through your upstream contractor. But a lot of folks almost overemphasize the value of that mechanics lien to the point where they think, if I've blown my mechanics lien deadlines, I don't have any other remedies. And that's not true. You actually, in most states, you obviously have a breach of contract claim for non-payment against the upstream contractor you reached an agreement with. But you also, in most states, still have a direct claim against the owner if they received the benefit of your work and materials and never paid the contractor for it. I get a lot, for example, I have clients in Utah that actually came to me and they said, we've blown our mechanics lien deadline, so we can't get paid on this project. And I said, how much do they owe you? And they said, $300,000. And I said, well, you can get paid. And we filed a lawsuit, and we included as defendants the owner and the contractor, and they got paid every cent almost immediately from the owner.
Oh,
Mechanics liens are certainly important, but they're not the end of the story. Does that make sense?
it does. And I'm sure a lot of people listening to this, maybe smaller firms, are relieved to hear that. So, yeah,
Sure,
definitely.
absolutely. Number three is that you have to understand how to recover your cost of collection. And this is really three and four. Contractors believe that when they're analyzing whether to go after a receivable or not, it's largely an economic decision. Sometimes it's based on principle, but more often than not, it's based on what's going to be the return of that investment, which I would suggest would be the appropriate way to look at. And as for three and four, you have to understand as a contractor that either you have a contract provision that allows you to recover costs of collection, which are going to give you your attorney's fees and also interest, or you have a right under state statute, and that's normally found in the Prompt Payment Act. So when you're factoring in the right and entitlement and decision to go after a payment from an upstream contractor or an owner, know that the Prompt Payment Act, State Prompt Payment Acts, and also your contract can give you the right to recover not only what you're owed for your work, but the cost of having to go after it. And that can be a valuable tool.
Definitely. So appreciate your national expertise on this because I'm sure each state does vary quite a bit. And we would talk before we got on the recording about how really business is being expanding way beyond state boundaries for contractors and projects. So I'm sure this is just super critical information.
Absolutely. And the final due for a pursuit of payment is to always request the contractor's surety information at the time you enter into the agreement. Sometimes you can ask for a copy of it as part of the underlying contract exchange between the party. But where that runs into problems is that you don't want to have a situation where you need the payment, cash flow is important, it's already delayed, which is the nature of the dispute, and you don't have the bond claim, so you don't know how to make the bond claim, and therefore you're asking the party that owes you money for a copy of their surety and bond information. They're obligated to provide it, so that helps, but it's much more convenient if from the onset of the project you say, if there's a payment bond on this project, I'd like a copy of that for our file. You put it in your file, then if a non-payment issue arises, you already know what you have to do and you can refer to it. I think as part of that fifth due, understanding the benefit and cost of pursuing a mechanics lien versus a bond claim is important. A mechanics lien threatens the owner's property, and that's why it gets their attention and it's valuable in that regard. But it isn't a pot of cash that secures your payment, it is a property, which means that you have to win your mechanics lien claim, take the property, hold a foreclosure sale, hope you get more out of the property than what you're owed, pay yourself back, and then refund the rest to the owner. That's time intensive. If you have contract provisions that require arbitration, it adds an additional layer of complexity to that. So the benefit of a lien is that you got the owner's attention if you filed a mechanics lien. But the detriment of a lien is that it requires a lot of work and it's time intensive. And if cash flow is a concern, that can be a problem. Contrast a bond, and the bond is a pot of cash. So you're going after actual money. You don't have to foreclose anything. The money is sitting there ready to be paid if you win. So understanding those respective rights, I think, is key to any collection process internally that you set as a company.
Makes sense. We're now to the don'ts. There
Yeah.
can't be any don'ts, can there?
There's a couple, and all these are really five don'ts that I don't think come to mind right away, but really are important in this process. The first is don't fail to consider collections when you're reviewing your existing contracts. The reason why is because they impact your ability to collect, what you can collect, and how you collect it efficiently or inefficiently. For example, a lot of contractors like arbitration provisions, and generally speaking, there's nothing wrong with them. But if you have in your contracts agreed to pursue any dispute with your upstream contractor by arbitration, you need to know that once that arbitration is done, you still have to then take that arbitration award, assuming you win, and you have to go register it, and you have to pursue collection. It's a whole second lawsuit. Arbitration provisions are very valuable because they keep disputes private between parties, but they're inefficient when it comes to collections. So what I always tell contractors is if the vast majority of your litigation or disputes are non-payment that you're owed for, then I probably would not suggest arbitration because you're going to have to file a second litigation anyway. On the other hand, if you're getting sued for defective construction or caught up in somebody else's claim, then the value of having that out of the public eye and in a private process probably outweighs the detriment that it's going to be a little more expensive and inefficient. The main thing is just take another look at your contracts with an eye towards your non-payment.
As you talked about upstream, like if I'm a supplier, I'm somebody more on the end of the food chain, as it were, than a contractor. I bet a lot of times people get sucked into project team lawsuits or more holistic lawsuits, and that in
Yes.
terms of your reputation.
In almost every state, all lien claims have to be brought in one litigation or consolidated into one litigation. And so if you're getting paid fine, but a different contractor isn't, and suddenly payment is delayed all over the place and a bunch of contractors are not getting paid and they all file liens to preserve, then you get wrapped into this big litigation with multiple contractors, and it can be slow and inefficient, but that's just how the process works. Second, don't fail to reduce retainage during your work. If your contract allows for retainage to be reduced from, say, 10 to 5% at substantial completion, make sure you enforce that, because you're shrinking the amount of money that you would be owed at the end of the contract. Also know that there are multiple states. In the United States, 20 states cap retainage at below 10%. You can't have retainage over 10%. And there are multiple states that actually require that retainage be reduced to 5% at substantial completion. If you know that, when the project hits substantial completion, you can demand that refund of retainage and shrink how much you're exposed in terms of non-payment at the end of the project. Interestingly, a state like New Mexico doesn't allow retainage at all. If you're working on a retainage project in Mexico, it doesn't really matter what you write into the contract. They don't allow retainage. It's almost impossible for contractors to know that law in every single state, but just know generally, and when you look at your contract, make sure that you're aware of when you're owed refund of retainage, because that can obviously be a large sum of money. Number three, don't fail to secure payment of retainage by your lien. So a lot of times what will end up happening is, with respect to early phase construction, excavation, foundation pouring, or site prep. For example, we had a project here in Florida where it was an excavation subcontractor, and there was 10% retainage on the project. They did their work, but they weren't technically entitled under the contract to a refund of their retainage late in the project, and it was a large project. So their lien deadline ran before they were actually entitled to refund of retainage. And what I always recommend is file your lien. You have to file your lien to preserve your right to recoup that retainage. If you are paid, but retainage is still sitting out there and you don't file a lien, then you don't have any security for that retainage at the end of the day. It does sometimes irritate your upstream contractor, but I've always found that they understand when you say, I need security for my payment and I did the work. And so as soon as I get paid, we'll release the lien. But make sure you preserve those lien rights, even with regard to return of retainage, particularly for early phase subcontractors.
As you were saying that, laying that out beautifully, Quinn, thank you for translating these difficult topics, by the way, because I'm tracking with you completely. But I was thinking about that. Let's say it's a project like $400 million, $100 million project, and you're the excavator, and it's like a 2-year delivery time
Yes.
frame. That could just cripple you financially to do your next projects.
Absolutely. And like I said, there is friction between you and your upstream contractor, because once the owner gets a notice of lien or they get a lien file on the project, but at the end of the day, it's not your problem. If you're paid, you'll release it. And if you're not paid, you have to have security, and the law provides for it. The one way to reduce that friction is, when you're entering into the contract with your upstream contractor, write in that the subcontractor has a right to file a mechanics lien to preserve all lien rights. That way, they can't claim it's a surprise. You can say, we agreed to it up front, and that helps a little bit. But definitely don't fail to secure your return of retainage through your lien rights. The fourth and very common problem we see, and fourth don't in receivable recovery for construction, is don't sign and return lien waivers before you get paid unless they're the right ones. So what we see all the time is we get contracts that say, as a condition of payment to the subcontractor has to execute a lien waiver for this payment. And so that's an understandable provision. But technically what you're doing is waiving your lien rights before you actually have the payment in hand. And that can be problematic. And the thing that is important is that it's actually a really easy fix. You just need to make sure that your lien waivers are conditional lien waivers, and that is conditioned on your receipt of the payment. If you make your lien waiver that you submit with your payment application conditional, then it actually doesn't become effective unless you get the payment. If you don't make it conditional, technically you've already waived your lien rights and you don't have the payment in hand. So the fourth don't is don't execute lien waivers before you've actually gotten the payment, unless it's the right type of lien waiver.
It seems logical when you say it, but I could see so many subcontractors or people further downstream on the project team, wow, really getting caught. And then what do they have in their arsenal?
That's right. And there are defenses. If you could, it's not a blanket rule that if you've already, it's very common. So it happens all the time. But there's no reason not to utilize a conditional lien waiver because then it really cleans up the record and you've certainly preserved your lien rights. If you found yourself in that situation, you still have options. But why get in a situation you can avoid by just using a conditional lien waiver from the beginning? And then the final don't is don't wait too long to begin collections. And here's the reason why I say that. Filing a mechanics lien, which is the most typical pressure point for getting payment, it requires a lot of work on the legal end. Mechanics liens typically have to be served on every party with an ownership interest in the property, which is not always just the owner of the project that you're aware of. If a bank has given a construction loan and taken a security interest in the property, that bank has to be named. If there are other contractors that have filed mechanics liens or have a security interest in the property, they have to be named. And if you don't name them, then you don't get to trump them with your mechanics lien. The problem is it's not readily available information. Best practice for us on the legal side is to run a title report, get the title report, then name everybody and serve notice in your mechanics lien. And now you've got security that trumps most, if not all, of those parties. I guess my point is that takes about a week or a week and a half time. Oftentimes we'll get contractors that say, hey, I've waited till the last minute because I thought they were going to pay us. They were promising payment, but I think my lien rights expire tomorrow. Can you pull a rabbit out of a hat? And we can certainly do some things in that instance. But when you're designing your system, as we talked about the very first do, make sure that you give a couple weeks, because if you can get that into the hands of legal with a couple weeks left in the process, they can certainly run the title report, get the information, and do a much better and more enforceable job of enforcing your right to payment.
This was so much great information. I could keep you on here all day, but you'd miss your next client appointment, which, if it's on this topic, I know is extremely time sensitive and significant. But we've been talking today with Quinn Murphy, shareholder with Sandberg Phoenix Law Firm, and he heads the construction and receivable recovery industry teams at Sandberg Phoenix for the whole country. And I'm so glad that you could make the time and share the expertise on this episode of Build America, Quinn. And three times is a charm. We would love to have you back another time as well.
Thank you so much, Kerry. I appreciate it. Always a pleasure.
Forward to it.